Okay. Morning. So, okay, you guys, thank you guys again for coming. Welcome. Hopefully we can get it all covered in the next hour. So, we're going to talk about new definitions in the RPA. Previously, there's a back page that has all the definitions. They've added new definitions, which you'll find definitions are on the bottom of page 12, which begin with item 25, and they go all the way to page 13. So these are some new definitions that are in the contract to help you better understand. So the first new definition is agent. What does agent mean? So before, that way they had it written out in the contract, it wasn't clarified as to who they were talking about. So it doesn't change the agency. It's the broker still is the agent of on the transaction, but it also makes sure to identify that the agent who is representing the buyer as well is also who's also licensee. They're also part of this transaction. So it's designed to incorporate all licensed agent parties, including corporations. So if you're a corporation or individuals. So it just makes sure that you are in fact listed on here. It breaks it down. It's a little bit more specific, but again, it does say here, it's not designed to override agency law. The terms broker, brokers, and brokerage are used on multiple occasions to distinguish the authorized broker from the other licensees working on the transaction. So that's a new definition on there. Another new definition is as is. This is something that I think a lot of times, you'll see in the MLS, they'll put, home is sold as is, and then the agents assume, oh, well, then that means you can't ask for anything, any repairs. And that's not the true case. So as is condition, it's the seller shall disclose known material facts and defects as specified in this agreement. So again, as is means however they disclose it, that's how they're selling it. Because if they were going to be fixing it, obviously they would say, but again, that buyer still has the right to inspect the property, and within the time agreed, whatever your contingency period is, you can request that the seller make repairs or take corrective action, or anything like that, or you can cancel. And that's simply what I tell my buyers. When we go in to look at a property, obviously as agents and buyers, we're not going in the attic. We're not turning on air conditioning, furnace. We're not doing any of those things. We're just simply walking through, making sure you like the area, number one. But if I'm walking on the outside and I notice that the AC is missing, well, obviously that's something that I can see. So in that case, you would want to write it on the RPA saying, hey, seller to replace air conditioning because it's missing, or whatever the case is. So anything that you can see with your eye, should be on the original RPA. But if there's something that you don't know, again, we're not licensed inspectors, neither are our buyers. That's what they do during their due diligence period. So it's just so they know what as is means. So they specified this in the RPA just so that way there's an understanding, that as is, it's narrowed down to as disclosed. So when you go to paragraph 7B, it further narrows it down where it says as is the present physical condition as of the acceptance date. So basically when you walk in and you view the home and it has, green carpet and it has purple walls, that's how you're buying it, unless otherwise agreed. So then at that point, you say, hey, I want a paint allowance, I want a flooring allowance, or I want whatever there is. And I've been around doing this for a long time. I know most of you have don't have as much years as I do, so I remember the times when we would do that. Now things are a little bit more competitive, so you're willing, like they say, to give them your firstborn just to get the offer, right? But back in the day, it was like, what, I don't like the color of that wall, I don't like this flooring, I don't like this, so I want you to replace it. I want you to do these things. And sellers were willing to do that. You know, some were, some weren't, you know, just depended. So everything is negotiable. So always remember that. But again, you have to be wise with your buyer also and just let them know that, you know, we're in a different market, you know, just based upon whatever market we're in. But just so they know, they always have a right to do a home inspection or any type of inspection to satisfy, you know, their contingency that they have in place. Okay, so does anyone have any questions about as is? We're good, okay. So the next new definition is days. Now it's getting a little bit more interesting. So you guys are going to get out of your comfort zone a little bit, because this is going to take something where if I were you, I would print this and put it in front of you so you understand what days means. Okay, so days means calendar days. Okay, however, delivery of deposit to escrow is based on business days. So there's certain things. So days means calendar days, but when performance is required, can be extended depending upon circumstances as defined in counting days. Now, we're going to get into counting days next, but so you have to understand, and this is going to be super important for your TC to know, what counts as days, business days, and actual when the escrow company is open days. So it's not as simple and basic. It's you know, everyone's different. So what would you guys say requires performance? When is, so where it says days means calendar days, but when performance is required can be extended depending on circumstances. As so what would you guys say requires performance? So when you have to perform, you're going to use counting days, and we're going to get into that next. Okay, so I just want you guys to really focus on this, and this is something that's super important to understand. And again, your TC or whoever's helping you with your transaction, you know, obviously when you open escrow is going to have to know these days to put it in place for you. But if you're doing it yourself, make sure that you understand these days, because it can, you know, mean your deal. So paragraph 3D1, that's where the initial deposit is the only time in the RPA where the term business days is used. Okay, so it means the days the escrow company is open. So let's just say, for instance, the escrow company that you're using is not open Thursday or Friday this week. There's some that are open Thursday, but not Friday. So it could change. So it's going to be dependent upon the escrow company if they're open or not. So let's say EMD, for instance, right? It's due within 3 days or 2 days or 1 day, depending upon what you negotiated. So if your offer is accepted on Wednesday, and let's say it's 48 hours, but they're closed Thursday, Friday, when is the deposit due? Business days. When is the deposit due? Acceptance is Wednesday. They're closed Thursday, Friday. When is deposit due? Wednesday. Yes. Because remember, today is day 0. It is not counted. You can't count Friday or Thursday. You can't count Friday. You can't count Saturday. You can't count Sunday. Day 1, Monday. Day 2, Tuesday. Day 3, Wednesday. Does that make sense? Okay. Now, counting days are as follows unless otherwise agreed. You're going to see unless otherwise agreed because, again, things can be changed. You can always, again, everything's negotiable, like I mentioned. There might be some agents, and again, pay attention to your counters because they might say EMD is due within 3 counting days. If they put that, then that's good. Then you agree to that. So it's no longer business days. So be mindful of that.
That would include Saturday, Sunday.
Yes. So make sure you're paying attention. So when you're receiving counters, that you're seeing the days that they're putting on there, because that can trick you. You know, it can be fooled. So number 1, the first day after an event is the first full calendar date following the event and ending at 11:59. So again, like I said, let's say you're served a notice to perform, okay? So for example, if a notice to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is personally received at noon on the 7th calendar day of the month, then the 7th day is day 0. That day does not count. Okay, because then at 11:51, it ends 0, and then the 8th is day 1. Okay, so for counting days, for purposes of counting days to respond to the notice to perform or calculating the close of escrow or contingency removal dates, the 8th of the month is day 1 for those same purposes. So remember, the day that you receive it, the day that offer is accepted, that whatever day that the performance happened does not count. That's day 0. Okay, so the next day would be day 1. All calendar days are counted in establishing the first day after an event. So all calendar days are counted in determining the date upon which performance must be completed, ending at 11:59 on the last day for performance. So again, if you have an agent saying, I need to receive that contingency removal by 5 p.m., no, you have till 11:59 to be in compliance, not 5 p.m. It's not end of business day, it's end of day, okay? After acceptance, if the scheduled performance day for any act required by this agreement, including close of escrow is an act, if it lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not Saturday, Sunday, or legal holiday, which could, because it's not an allowable performance day. And again, it ends at 11:59. So that would be, let's just say you guys get a demand to close escrow. Okay, and let's just say it ends on a Saturday. Well, obviously you can't perform on a Saturday, you can't perform on a Sunday, so it would take you to Monday at 11:59 p.m. Okay. For the purpose of close of escrow, any day that the county recorder's office is closed, the close of escrow shall occur on the next date that it's open. Okay, so again, it's just giving you the breakdown of, if you can't perform, you can't perform. You know, it's beyond your control. Close of escrow is considered day 0 for purposes of counting days seller is allowed to remain in possession. If again, if permitted by this agreement. So if all you're doing is saying seller can remain in the property 10 days after close of escrow, well, the day escrow closes is day 0. The next day starts 1. So that's how that's counted. Does anyone have any questions?
We found, for example, during the holiday season, our the 25th and counted or previous installation for your state.
Yes. So days in escrow, yes, but you can't obviously close on them.
Okay, I got an offer accepted on Thursday. They give me 10 days for everything. Inspection, it's kind of tough because I told her, everything is closed. You make appointments. You can find for inspections.
Yeah.
Okay, I still got it. So now it's from Thursday, so I have it till next
Tuesday? Was it Tuesday? Right? That would be 10 days?
Thursday. Last Thursday, I got it accepted.
Oh, Thursday. Okay.
So, but he didn't say calendar day, so yeah, 10 days.
So it was accepted on the 10th?
Uh-huh.
I mean, on last Thursday, the 23rd?
Tuesday.
So the 10th would be on a Sunday. That would be 10 days, the 2nd.
This Sunday.
Yeah.
Yeah, that's what I told my buyer. We went to the city like yesterday. No, they usually yesterday. They said, okay, you need to do everything you need to do. So by Saturday, tell me, what do you think?
Yeah.
You also have to receive.
Yeah, I told the agent yesterday, I need to have all.
Yes.
I prepared all disclosures tomorrow. It's today.
Well, you have 5 days from receipt. So if you go back to the first pages of contingencies, it shows on here, on page 2 at the bottom, it documents fees and compliance. It shows seller delivery of documents 7 days after acceptance, or you can put in a different date. So if they don't comply within whatever timeframes here, you can send them a notice to perform, obviously.
Yeah.
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 But if you notice up higher where it says review of seller's documents, you have 17 days, or if they said 10 days for everything, but if they give it to you on day 9, it automatically goes, you have 17 days or 10 days, whatever they said, or 5 days after receipt, whichever is later. So even if they don't send it to you until Sunday, you still have 5 days.
5 days from the delivery.
Yeah,
If they're delivering to you 15 days after, and you say, I don't want it, they're like, well, usually, no, you have to deliver everything to me.
yes.
To make a decision, so therefore, if you want to cancel, you cancel, because we, even if we could have been 2 days, it's still got to be, any disclosure.
Yeah.
So how can I make a decision?
You can, if on the new contingency removal, it does break it down a little bit more. You can remove your physical inspection portion of it, but you don't necessarily have to remove your reports or disclosures.
Yeah, because I still don't have, I mean, I'm gonna go for it.
NHD and termite or whatever you asked for.
Yeah, so my plan was, if we get to Friday, we still need it, I just ask for an extension.
No.
I would
You don't have to.
anything.
Not if they haven't given you
Why?
that, I mean.
No, they gave me like, yeah.
No, but you don't have to. Just do your part, which is the home inspection and whatever inspections, your client feels necessary. And then just send the CR for, your physical inspection portion of it. But you don't have to send it completely waiving your complete inspection.
Yeah, she's asking. We were, everything was good. The next 2 days she was asking. I want the contingency removal, okay? I want the contingency removal. And
Yeah.
once they send the deposit, I go, because it was open until Monday and I sent it Monday. I go, Escrow sent me, Escrow instruction on Monday morning, and they went 2 hours later to deposit the money.
Yeah. Okay, so we'll move on.
Isn't that big secret?
So otherwise agreed, this is what I was saying, that there's otherwise agreed means an agreement in writing signed by both parties and delivered to each. So like I mentioned, the RPA is written one way, but again, you can always change it. Everything's negotiable. So that's the purpose of the addendums and, everything else that's incorporated into the RPA or could be attached to. So you're going to see otherwise agreed in a lot of different areas in the contract. So this right here is the new delivery framework, okay? So what does that mean? Okay, we're gonna get into that. So the required elements to create a contract. Number 1, you send an offer. Number 2, acceptance, exceptions. There's 2 acceptance. There's 2 parts, sign and has to be delivered, okay? And then 3, the consideration, by the seller to determine if they want to accept the offer or not. So those are all the elements required to create a valid contract. So delivery has been redefined. Okay, so delivered, or delivery of documents, again, unless otherwise agreed, means and shall be effected upon personal receipt of the document by the buyer or seller or their authorized agent. Personal receipt means copy of the document, or as applicable, link to the document, is in the possession of the party or authorized agent, regardless of the delivery method, via mail, via text, or other. An electronic copy of the document, or as applicable, link to the document, has been sent to any of the designated electronic delivery addresses specified in the real estate broker section on page 16. After acceptance, agent may change the designated electronic delivery address for that agent in writing, delivering notice of the change in designated electronic delivery address to the other party. So links could be, for example, Dropbox, Google Drive, or another functionally equivalent program. Because if you notice, there's some agents in the MLS where it says, don't email me the offer, upload it here, or place it here. So it's saying that, that is, they are allowed to do that. If the recipient of a link is unable or unwilling to open the link or download the documents or otherwise prefers delivery of the documents directly, recipient of a link shall notify the sender in writing within 3 days after delivery using car form RFR. In such case, delivery shall be effective upon delivery of the documents and not the link. Failure to notify sender within the time specified above shall be deemed consent to receive and buyer opening the document by link. So we're gonna get a little bit more into this. So what's an authorized agent? Before when we wrote an offer, it said authorized agent means the individual real estate licensee specified in the real estate broker section. So if you're writing the offer, you're the authorized agent. It's used to identify the individual who's authorized to accept electronic delivery of documents, email addresses. You're going to notice there's a designated electronic delivery address on page 16 of the RPA. So if you've written an RPA, you'll notice that it asks you for an email of where to receive the documents. As a result of the new delivery definition, it's imperative that the authorized agent monitor email communications relative to the transaction. In line with the mailbox rule, also called the posting rule, which is the default rule under contract law for determining the time at which an offer is accepted, states that an offer is considered accepted at the time that the acceptance is communicated, whether by mail or email. Okay, so let's talk about the old process and the new process. Before buyer made the offer, buyer's agent delivers the offer to the seller's agent. Seller's agent presents the offer to the seller. Seller signs the acceptance. Seller's agent delivers signed acceptance to buyer's agent. And then buyer or buyer's agent's initial confirmation of acceptance. A binding agreement is created when a copy of the signed acceptance is personally received by buyer or buyer's authorized agent, whether confirmed in this document or not. But that is when the contract is binding. Okay, so the new process, buyer makes the offer, buyer's agent delivers the offer to seller's authorized agent to the designated electronic delivery address. Seller's agent presents offer to the seller, seller signs the acceptance, seller's agent delivers signed acceptance to buyer's authorized agent to the designated electronic delivery address. No confirmation is required anymore. So what do you think's changed there?
So on the bottom of
The confirmation, because you're trying to file, you gotta get confirmation.
And on the old RPA, so like, let's just say, for instance, when, if let's just say, a lot of times agents were a little bit confused, and I think that's kind of why they took it off, because agents would say, well, our acceptance date is based on the confirmation date, but it's not, it's actually when the seller signed. But so there was a lot of confusion, I think, with a lot of different agents. So
Yeah, because some people would say it was the last date on the contract, the last signed date.
yeah, and it would get confusing. So they're trying to make it a little bit more where it's understood across the board. So remember, no confirmations accepted. So if you've filled this out, it says designated electronic delivery addresses on page 16. So here is the email. Here's a text number or alternative. If checked, delivery shall be made to alternative designated electronic delivery address only. So you can add another person or add a different way, but you can say that once they get the email here, it's accepted. Okay, so you don't have to go back and say, I still have to confirm it. So make sure that it's right, okay? That you have the right email, and like they said, that you're checking that email. Does anyone have any questions regarding that? Oh, yeah, yeah. Okay. So the next item is lease, liened, and attached items. We kind of went over this in the last class in regards to what's included and not included. But now the seller, they made, they made it part of the contract where the seller is required to disclose any leased or lien items. So, and they have so much time to do it. Again, it's going to be on paragraph 3N. Number 1 is where you're going to find how much time they have. And again, that's negotiable. You can always, change that on the contract. So they have to disclose to buyer if any item or system specified in paragraph 3P or 9B or otherwise included in the sale is leased or not owned by the seller or subject to any maintenance or other ongoing financial obligation. So remember, sometimes there's solar, which is obvious, but maybe they have a water softener, maybe they have, it's a smart home and maybe they have, certain alarm system and they're in a contract. So the buyer needs to know if it's something that they have to take on. So it's important when you are listing a home to have a checklist, or to have even the MLS input data sheet that, I take, because it gives you everything broken down and it'll remind you to ask those questions, because a lot of times you're busy talking other stuff, you leave and you totally forgot to ask. Now you're receiving offers and now they're like, oh, so they're taking the solar, right? Wait, what? You didn't know, it happened. So that's why it's important. So, and they also have to deliver to buyer all written materials. So the lease, the warranty, the financing, concerning any such item. Okay. And then there is a contingency for the review of leases and liens. So the buyers do have, this is part of their inspection period. So again, remember, if you don't get this, number 1, you need the disclosures, because maybe you don't even know that there's something that's lease or liens until you get disclosures. So once you get disclosures, let's just say it says, hey, there's a lease on this, whatever it is, oh, well, we didn't know that. Now we need to review the paperwork. So now that's going to buy you more time, because now you have the right to review, whatever you're assuming, you need to review the terms and make sure your buyer's okay with that. Okay.
How many days to review?
5 days, always 5 days. Yeah, the default is 5 days, unless otherwise agreed.
I love that.
Yeah. And then it does tell you, seller, after first delivering a notice to buyer to perform, may cancel this agreement if buyer, by the time specified in paragraph 3L, refuses to enter into any necessary written agreements to accept the responsibility. So if the buyer doesn't agree to accept the terms of whatever leases or liens, then the seller can cancel, because they're not, obviously they're not going to move forward. So we did talk a little bit about this too last time. Vesting changed to buyer entity, not assignment. So buyer shall have the right to assign all of buyer's interests in this agreement to buyer's own trust, or to any wholly owned entity of buyer that is in the existence of the time of such assignment. So again, a buyer can change from an individual to their trust or to their corporation or LLC. They do have the right to do that. They can change their vesting, and this is all done, within a time amount with escrow. Okay, most assignments require a request. So although it can't be withheld, a reasonable request can't be withheld, but usually they want it done within 17 days, because then it can hold up, the escrow. So buyer shall not assign all or any part of buyer's interest in this agreement without first having obtained the separate written consent of seller to a specified assignee. So they need to let the seller know, they have to agree, basically, which there's no reason why they wouldn't, they wouldn't agree. But so cancellation. I know we talked about this too, last time, a little bit about this. So disclosure regarding possible loss of deposit. The retention of the deposit, it's in paragraph 29. If initialed by all parties or otherwise incorporated into this agreement, specifies a remedy for buyer's default. So in 29, that's on page 14 of the RPA. That's your liquidated damages clause. You always want to sign that. And you know, a lot of times, yes, you have the buyer's interest, that's your buyer, but again, you want your buyer to also know that they have something to lose if they don't perform. Because if they know they have nothing to lose, then there's no urgency for them, or they're not respecting the time of that seller. So you always want to make sure that they understand, because when you send it to them via DocuSign, it's going to say optional. And they're either going to skip it, or they might ask, it's saying optional, do I have to sign this? So you want to make sure that you let them know the importance of signing,
That's the show on the other side.
when you send it as a DocuSign for your client to sign, yes, it shows it optional.
Can you make it?
Maybe, I've never done that, but you know what? That's a good question. You probably
Well,
can.
on the first, on the old RPA, if you look at, on DocuSign, it wasn't the same color as
Yeah,
it was gray instead of yellow or blue or purple. But if you deleted it and manually dragged it, they didn't have an option.
so maybe, yeah, that's what I'm thinking. You just have to do that, yeah.
On that one.
A buyer and seller are advised to consult with the qualified, real estate attorney before adding any other clause specifying a remedy for failure of buyer to complete the purchase. Any such clause shall be deemed invalid unless the clause independently satisfies the statutory liquidated damages requirement set forth in civil code. So obviously you don't want to change any of that, but this is where they're talking about, how some people put your deposit automatically lost or this or that. You can't, it has to be legal. Like that's not California law. It's not set forth to be automatically lost. Mutual instructions required for cancellation. So this hasn't changed. Effective cancellation on deposits. If buyer or seller gives written notice of cancellation pursuant to rights duly exercised under the terms of this agreement, the parties agree to sign and deliver mutual instructions to cancel the sale and escrow and release deposits. So remember, fees and costs may be payable to service providers and vendors for services and products provided during escrow. So that's why it's important to always let your clients know, if they do a home inspection or if they do, an appraisal, or even sometimes HOA, or if there's certain things that if they do cancel, they may not get, a refund on that money. Sometimes escrow has to order certain demands too, so they may charge a cancellation fee. Also, we had talked about that. Some escrow companies do have it in fine print where it says there is a cancellation fee of $250, $500, $750. I've seen, depending upon how much
It's
work
12 o'clock.
was put into the file. So a release of funds will require mutually signed release instructions from both parties or a judicial decision or arbitration award. So again, they're not going to release it unless both parties agree. A party may be subject to a civil penalty of up to $1,000 for a refusal to sign a cancellation if no good faith dispute exists. So if the seller just says, I just don't want to sign it just because I don't want to sign it, they can be fined. Okay, so neither agents nor escrow holder are qualified to provide any opinion on whether either party has acted in good faith or which party is entitled to the deposit. So buyer and seller obviously are advised to seek legal, advice, because
They didn't change it to where you have a specific time to have your seller sign that cancellation.
no, it's just within reasonable time. So, and we talked about this before, last time. I think we got into the cancellation where you're not supposed to open up another escrow, you're not supposed to do those things. So, But again, we've seen
Well,
some
that's
things
escrow's-
happen.
That's escrow's discretion, right?
Yeah, but some agents will take it to a different escrow, so they don't even know that there was another escrow existed. So they take it somewhere else. We've seen
What
that.
if we close and another escrow? What happens?
Your seller's responsibility.
And the money's still over in,
And the other escrow?
if I was the buyer's agent and I saw that happen, I would send you a demand to close it, because now your seller no longer owns that property. And they could probably take you to court to get it released if they wanted to go that far. Because now you went on and closed, which was illegal on the seller's part. So, yeah,
What kind of demand?
you can send them like just a demand, just, a demand. No, you just, write in a letter demanding that, hey, I've seen, this is what I would do if I saw Brenda closed with buyer, another buyer, and my money's still in escrow. I would, let escrow know, hey, I'm just letting you know that, you're in violation, because if it's the same escrow, if it's not the same escrow, which I'm not sure if it is or not, because it doesn't say what escrow company obviously closed the deal. But believe me, when you send something like that to escrow, they're gonna look into it and say, hey, you can send it, to both. Yeah, you can send it to all parties. But escrow is gonna be the one, because they don't want any problems. And that's the thing, most agents don't want problems either. And that's kind of why we negotiate, because once someone makes a complaint about you, whether valid or not, you're investigated. Nobody wants to be investigated. So that's why a lot of times people are willing to compromise and negotiate at that point. Does anyone have any questions about that? Nobody would likes to cancel. Canceling is not fun. I think it's really important to communicate, with the agent, from day one. So that way you guys have a mutual understanding. I think it's important for everyone to kind of be on the same page. It's like, you know what, you respect my seller and I'll respect your buyer. We're working together to make this happen. But a lot of times some agents want to feel that they're strong arming you. They want to feel like, yeah, they want to boss you around in the transaction, and it's like, so I think that's when what you're dealing with. You're kind of like, okay, so just just follow the contract, the way for your party, whoever you're representing. And if you need an extension, you need an extension. It happens, things happen. A lot of times every agent works differently. You're going to receive, like, I know Elliot, I think it was Elliot, she received a notice to perform before the date was actually, or someone, I forget which agent called me and said they received it. So it's just that agent that's just how they do work. They're on top of it. They want to make sure you don't go past it. And there's others that are kind of like a little bit more lenient, but we have to make sure that you're in line, because if not, then your sellers, remember, are gonna say, hey, what happened? I thought you said they only had 10 days. We're day 14. What
I got a
happened?
notice to perform, and it was before the date.
Oh, it was you?
Yeah.
Okay.
And I was like, wait a minute, we're not even at the time. Like, what? Why are you sending it? And it was a holiday. It was Thanksgiving. So I went off on him. I'm sorry, I crossed the line. I know I shouldn't have crossed. And I'm like,
Because there's something about getting a notice to perform where you feel like it's fighting words,
I see Tiffany on that email. She was like, what? I was like, absolutely not. That was so out of line.
Yeah.
I went off. In a
Yeah.
proper professional manner. But
Yeah. That's funny. So basically, what I'm gonna do is that concludes like the information of everything I wanted to go over. But what I'm going to do right now is I'm going to give you guys copies of the addendums, which are the on page 4 of the RPA, a probate agreement addendum, a manufactured home purchase addendum, since those are the ones that are the most common. And that way you guys can see if there's anything on there that you guys need to have completed when you're submitting those offers. And is there any other addendum that you guys want to go over?
Why did you offer with that, the new RPA? That I saw yesterday, and I had a question on it. Is that page 4?
Yeah, this is page 4. So again, if you guys notice, remember that pages 1, 2, 3, and then just the top of 4, if there's anything to be attached, is all that's needed to be filled out. Everything else is just explanations, which I like it. I like that everything's in the front. I think it makes it easier. And it's pretty detailed, which is nice. But you guys should have your samples.
What happens if, we go look at a property and let's say it was nighttime or whatever, and we didn't notice if it had Ring doorbell? And then we'll go do a home inspection and they're like, oh, it has a Ring doorbell, but we didn't include it in our.
Well, at that point, you can ask if it's included, because if it's not, now they make it here.
Yeah.
They're making it here. Well, what I would do is, as a template, I would like, just like stoves always marked whether it's there or not, I would always check the video doorbell. Because it's very common, you know, and then it's gonna be the seller's duty, their agent, to take it off. So put it on them. Well, it's better to be templated, include it, and them to say, oh, there's no ring doorbell. Okay, no problem. We'll take it off the contract. But I do, even like anything that says smart home, you know, control devices, they have electric car charging station. That's pretty cool. They even have dishwashers. Before it never was, because it was just assumed that the dishwasher stayed. So like I said, when you do your template, just mark those. Even mark the wine fridge. Huh? Yeah, some don't. Yeah, some don't. But the ones that do, it was just automatic, they stayed, you know, you don't deliver it with, you know, a hole. Yeah, they didn't mark it, so I'm having a yard sale. Yeah, the little beverage, uh-huh. Yeah, a wine thing, or a beverage center, as they call it. Yeah, so in just, like I said, you can always overmark, because all they're gonna do is counter you back. Like, that doesn't apply, that doesn't apply. They're like, dang, what house did you look at? You know what?
That's how I was when I was typing that offer. I was like, damn it, did that thing have that? And I'm like should I check all this? And they're gonna be like, this is the wrong house.
Oh. Yeah, no, I think it wouldn't hurt. It wouldn't hurt it at all.
It was like 6 o'clock at night.
Yeah. And then let's see. Let me look through this real quick. So we went over all of that.
Like, see, on page 4,
Mm-hmm.
I guess looking right now, that it says, it has for septic, well, property, propane, vendor.
Yes.
And that house happened, but I send it separately.
Yeah, you can. You can, if you know you can attach it, you can send it separate. It's
When
fine.
you check those boxes, some of them attach it already. When you're typing up your offer and you check the box, it'll link it, and then you just attach. It's already there.
Yeah, but I didn't mark it on the offer, I just put it in.
Yeah, yeah. Yeah,
But I
you,
send the addendum.
but you can send it with it, right? No, that's fine. But all it does by marking this, it just makes it it's all subject to whatever's in here. It just separates it. That's all. I mean, it's not a big deal or not, but the whole purpose is just so that way they know it's part of.
How can I get someone for a well to inspect it? Because they're not doing anything on that, only for the septic tank, they got no certified. They have a well and tanks, those propane things.
Yeah, there's
You have
companies.
to follow the well and water company. They do water tests and well tests.
And when we do it like. Yeah, because I told the buyer, look, they not doing anything of this, so.
Is it in Northern California?
No, it's in.
Here and Homeland.
Oh,
So, and I said, you have to do your own inspections. And if you don't like it.
Oh, well.
Just kidding. But you don't wanna do any, not even the home inspection.
have them sign the
What do you
waiver.
do?
Have them sign the waiver.
Yeah. He said, what the inspection gonna tell me? I know it needs a lot of repair, so it's cash. Okay. He said, with that money, I can fix something.
Yeah.
He said, the water is running. So there's water, and it has pressure. So once we go, but I went to the city and there's no permission for the well. I go, good, I bring you guys to the city so you guys can see, you know, everything. Now you want it? And the second half, we have a, permission and what we have.
Is the well on their property? It's not on someone else's
Oh.
property, right?
Oh, yeah, it's
Like tethered on to.
I know.
yeah, the fence is a little bit.
Okay, so let's see.
I did have a question